Hey everyone, Harry here to give you a quick report on today's Supreme Court opinions. Everyone, of course, is waiting with bated breath for the immunity opinion, and they do have, or started the day with some 12 or 13 cases, depending on how you count. Immunity didn't issue, and the other biggest cases didn't, but one fairly big case did, and both cases were noteworthy. So the first case that came out was Justice Barrett writing, Amy Coney Barrett. And it was significant for starters just because of the lineup, because it was with 6 justices. Those are the 3 progressives, Chief Justice Roberts, Kavanaugh, and her. In other words, what would pass as a center block of the court, depending on how you analyze things, Roberts, Kavanaugh, Barrett, are there with the progressive block of Jackson, Sotomayor, and Kagan. And the case, you may have heard about it. It's a very interesting First Amendment case in which a couple states and a couple users say that the government was violating the First Amendment by pushing on, or this is part of the case, of course, persuading or urging, depending on how you want to characterize it, social media companies not to issue kind of crazy bullshit about COVID, right? And this crazy bullshit, however, has abided and remains a live debate on the right, especially about should one get vaccines, et cetera. Government's policy was really to try to urge people and to take medical measures and to try to counter loud voices on the right trying to, keep people from getting treatment, and they were dying and the like. So they are pushing on the social media companies to include medical information and try to actually act according to the facts as the government saw the facts, and as best as I can tell, as the facts really were. This is a case that really goes to the heart of the MAGA characteristic of just lying all the time, or stating a fiction and staying behind it. So the holding here is that the people don't have standing. The 2 states and the users really don't have the standing to make the court take up the case. They're really, for one, looking to the future, asking for an injunction not to do this anymore. And then for 2, it's just, what is their injury? Because again, the social media companies are not suing. So 6 members of the court say no standing. And it's noteworthy that the other 3, Alito, Gorsuch, and Thomas, you would normally think of them as good conservatives as being on the side of no standing when it doesn't exist. The whole standing focus was really inaugurated by the godfather of the modern conservative movement, Antonin Scalia, and it became a real hobby horse of the right generally. And here you have Justice Alito saying for 3 of them in nearly apocalyptic terms, this is one of the biggest First Amendment cases ever. It's actually very telling. This is what people are often accused of doing, and it's typically people on the left, when in standing cases, he goes on and on about the importance of the case and how huge it is, before ever tries to mention or counter the arguments that these particular parties before the court, 2 states and a couple folks, individuals, just don't have standing. And that, in theory, right, there's no real connection between the gravity and importance of a case and the standing analysis of the people who happen to be before them. The big point here is the social media companies weren't there saying our rights have been abridged or were being abridged, and so you needed to find sort of sympathetic plaintiffs to come forward, and that would be the normal suspects of conservative state attorneys general and certain individuals. So that's going to get real play. And I've seen a study. I don't want to be too glib about this without reviewing it, which I haven't been able to find this morning, but that basically suggests that Alito's standing analysis really varies in cases where the court isn't unanimous on standing. The best predictor is sort of the conservative result as opposed to issues of standing, like how speculative is the claim and the like, which would suggest a kind of result orientation that is part of the kind of general case against Alito that's been mounted in the last many months. Okay, and then just briefly, Snyder versus U.S., that's 6-3 the other way. The three progressives are on alone, and Kavanaugh writes for the 6 members of the court. And the holding is that the bribery federal statute, the so-called 666, isn't violated when an official has done something, has completed it, and gets a so-called gratuity in recognition of it. And the court is clear that it's talking about gift cards, free lunches, although the actual gift here was a little bit more concrete and valuable, a $13,000 check to a mayor. But that's the remand. Is this a gratuity or not? But in any event, the conservative bloc of the court is really concerned about white collar statutes and whether they give fair warning and whether they criminalize what the court sees as just ordinary political activity. And so that's what this is classified under. So the bribery statute doesn't include gratuities. We'll see how that plays out, but especially there will be factual disputes here. I mean, I can imagine really big factual disputes. You indict someone for bribery and they say, oh, but I'd already decided to take this action, to give the contract here. That was done. And that's where the sort of action is on the evidence. Because if it's done and it's just a gratuity, kind of like a dinner, I'm all done already, and then I'm just adding on and wrecking the restaurant goer, or here the person who's gotten the benefit of the official action just is giving some thanks for action that's already done. So in other words, different from a quid pro quo where the gratuity or the thing of value influences and is the causal factor of the official action. That could be a little bit of a tricky and muddy area, but the basic notion is, if it's just gratuity and it's already been done, it's not a bribery, even though that might fit, by the way. This is also consistent with the court, the plain language of the federal bribery statute 666, but the court, as it's done in a number of cases, wants to narrow that and keep federal statutes like this from being, as it's concerned with, traps for the unwary local officials just doing politics as usual. All right, there are the 2 cases, still 10 to 11 to go. We're announcements Thursday and Friday. Those would be 2 really honking big days to get out everything. But if they don't, and it goes to Monday or Tuesday, there'd be nothing unusual about that. The one thing that I said is, man, it would be a bad joke on the court's part to issue immunity tomorrow, the day of the debate. I think they've got to be aware of that and got to avoid it. Otherwise, though, if they do issue a lot of opinions tomorrow, like 5 or 6, that'll be an indication they're, sprinting to the finish line on Friday, because as of now, that's what the announcements are: Wednesday, Thursday, Friday. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.